Check, check. If we can get everybody to file in, we're a little bit behind. I try not to be a little bit behind, but I'll give it 30 seconds here to see if we have anybody in the hall. Moving forward, there looks like we got everybody in. I'm Travis Gray with the Division of Oil, Gas, and Mining. The next best thing to John Rogers, who's typically up here. But John's not with us today, so they asked me to step in. I've had a big hand with the collaborative meetings in general, most of it down in Carbon County. I do work out of the Price office, so heavily involved with these for sure. But anyway, welcome everybody out. Glad to see you for obvious reasons. We get everybody together in person. We can make those connections and have the conversations that really get things moving. Sometimes we're all guilty of getting stuck behind emails and things just don't move. So when you get together in person, usually those things happen a little faster. So that's part of the point for obvious reasons. And then to touch about some of the items that are on our agenda. I apologize, it's my fault. There's not enough agendas to go around the room. If you're on this side, Orland took really good care of you and everybody got one. And anyway, we were sparse over here. So share them around a little bit as needed. We're a little short on those. A little bit to talk about production-wise. Don't know if Matt had that up yet. He's usually ahead of me. But in Matt's defense, I don't know where I'm at, so how would he know? Really good news, though. Exciting stuff with production when we start talking about that. It's up on both sides of the spectrum when we talk about natural gas or if we talk about oil production. Both sides are really trending up, and you could go into the weeds a lot on why that's happening. But natural gas specifically, we'll start with that. January of 2023 at 27 MCF and now at a 7-year high. So we're sitting at 28 MCF right now per month. Natural gas is really on the rise. Specifically, the Ballard area has got a big increase of production with natural gas along with the oil that they're producing there. Outlying areas down in Carbon County, urban oil, gas, and mining has really gone off the charts, and they've gotten very aggressive, and they're producing lots of natural gas in the Carbon County area. So they're just two main factors. I mean, obviously everybody's involved, but those two entities specifically have really isolated the increase. Moving forward, if we could, to oil. Oil is continuing to climb. We, just looking, we're still on natural gas, right? Bump us to oil. Oh, I got it, my fault. Sorry, Matt, I thought you were driving. I'm driving, that's the problem. All right, sorry, now we're up to speed. When you look at oil, like that's an awesome chart to look at. It's on a big trend in the right direction. Right now, sitting at roughly 5.9 million barrels per month. Oil has set a 3-year record, and it continues to do so. That increase each month is roughly 10 million barrels, each year. So not only the fact that it is increasing, but it's increasing by such a large amount. And obviously the horizontal stuff has changed the game. Technology has changed the game. There's multiple reasons on why oil production is up, but nonetheless, a 3-year high. So, and it is trending, looking to do that again this year. So major increases from both sides, natural gas as well as oil. So setting that aside, that's probably enough from me, but let's jump into our presenters. Today, we have Kathy Davis and Clay Crozier with us from Public Lands Policy Coordination Office, Uinta Railway, and Good Neighbor Rulings, and we'll have them guys speak. Thank you.
Okay, so today I just wanted to take a quick minute to introduce myself. I'm Clay Crozier. I live here in Duchesne. I am legal counsel for the Utah Public Lands Policy Coordinating Office, and that's kind of a mouthful. Most people just call us PLIPCO. So our central functions are really threefold. We coordinate with all the federal agencies on all federal land use issues. We do policy work, so We help the state create plans, and then we follow up with the federal agencies and advocate for our plans with them. And then we have a litigation arm where we've got, what is it, Kathy? We've got the most cases in any civil division.
74, I believe.
Yeah, we've got a case count of 74 cases against federal agencies on land use issues with the federal government. So we do a lot of things. We're a small office, but we hit heavy, and we coordinate with all the other state agencies in advocating for Utah's interests on federal lands. We primarily work with the BLM and the Forest Service, but once in a while we get tied into like the Bureau of Reclamation or the Mitigation Commission or USDA, and so we get tied into all those issues. And we do a lot of federal administrative law. And that really starts with, when any federal agency goes to take an action, they have to do scoping and NEPA, and each step of the way, each cooperating agency is giving input on how the plan should change or things that the federal government needs to look at when they're pursuing a permit or a plan. So we stay pretty busy with that. I will tell you, I don't consider myself to be a air quality expert because we do mostly land use things, but we end up getting tied into it because a lot of these projects, especially coal mines, oil and gas lease sales, and APDs and stuff, there's got to be a certain degree of greenhouse gas analysis that's been required historically. Now, a lot of the actions that the Trump administration has been taking has really pared that down, and I think there's even an executive order out there saying you've got to get rid of greenhouse gas analysis. But for the time being, we're still pursuing forward as if that's the case. So I wanted to talk to you today about a saga that's unfolded, and it's really affected Utah over the last few years. The good neighbor rule. I'm sure all of you have heard this in some form or another, but I think the most helpful case to understand it is Ohio versus the Environmental Protection Agency. That was decided last year. And what it comes down to is the Clean Air Act sets up this framework where each state has to have a state implementation plan, or a SIP. And that SIP has got to contain adequate provisions that prohibit, consistent with the provisions of the Clean Air Act, any source or other type of emission activity within a state emitting an air pollution which will contribute significantly to non-attainment in or interfere with maintenance by any other state with respect to any such national primary or secondary ambient air quality standard, or interfere with measures required to be included in the applicable implementation plan for any state or any other state as talked about in the Clean Air Act. So the reason that this is interesting, it's meant to address interstate pollution, and the Clean Air Act envisioned this system where the states can all work together to try and affect air quality, because there's such a thing as upwind states and downwind states. So we joke that the upwind states blow all the hot air, and the downwind states have to suck it all up. So it's kind of like, Congress. They blow a lot of hot air and we have to deal with it. But so the states have the primary responsibility. That's something that I think we need to understand is under the Clean Air Act, the federal government wanted the states to have the primary responsibility and come up with the plans and how to adhere to these air quality standards. And so the way it works is the EPA, through the Clean Air Act, they will decide how they will set the standard for the air quality, and they will find these pollutants and say, this is how you've got to regulate it. Then the states have to submit their state implementation plan and of how they're going to address and keep those within, so many parts per billion of this chemical in the air or whatever, and how they're going to enforce it. And then this EPA looks at the plan and says, okay, this one meets our standards, we'll approve it, or this one doesn't. And if they decide the plan doesn't meet the standards, then the federal government can create a federal implementation plan, or what's called a FIP. And that's what led to all the drama starting at the end of the Obama administration. Towards the end, the Obama administration finalized a rule that raised the national ambient air quality standards for ground level ozone. And you hear that term a lot in this meeting because ozone's a big thing out here in the Uinta Basin. So this change, because they changed the standard, that required all the states in the union to create a new SIP to address that standard. And it only gave them 3 years to do it. So in 2018, we've got a new president at this time. Trump wins, and some of the states submit their plans, but there were some guidance documents put out there that they're going to do something about it, so the states really don't have to submit their plans. So a lot of states didn't. And then by 2022, so President Biden's been in office now for a year, and they began formally approving certain plans and disapproving certain plans. And that include, at least in part, some of Utah's plan, but there were ultimately 29 states that the EPA determined did not meet their applicable requirements under the Clean Air Act. And so the Biden administration, with those 29 states, created a federal implementation plan. And it created this big, they gave states emissions budgets of how much they could emit, and they created an emission trading plan. So you've probably heard about like carbon credits and how upwind polluting states would have to buy essentially credits from downwind states to be able to pollute more. And that's the system the Biden administration proposed. Well, by 2023, about every state in the union was suing on this thing because nobody was thrilled that they were going to have to be buying credits and be given budgets from the federal government, and also a states' rights thing. The states didn't like that that the federal government was coming down on them hard, even though they thought they put forward what we considered a good plan. And I think the state of Utah's plan was a good plan. So this issue arose where some circuits, I'm sure you all know, but I'll say it anyways, the United States of America their judicial system is divided up into a bunch of different circuits. There's the First Circuit, Second Circuit. We in Utah are in the 10th Circuit, and it consists of a bunch of the Intermountain West states and even some of the Midwest states. And so if you're in the 10th Circuit and a court issues a ruling, that would only apply to the 10th Circuit states. But if you're in the First Circuit, that ruling wouldn't apply to you. So now we've got all these different states operating on different playing fields based off different rulings. And so some circuit courts issue a stay of the rule saying you don't have to abide by this during the course of the litigation. Things are going to go as the status quo until this thing gets resolved. And then in 2024, the Supreme Court granted a bunch of the states emergency stay request, and they paused the rule. And then in 2025, so just earlier this year in March, President Trump announced that they were going to rescind the rule. So let's specifically go into Ohio versus the EPA. So ultimately, the Supreme Court paused the rule during the course of the litigation, and they decided that it violates the Administrative Procedures Act because the rule was arbitrary and capricious, it wasn't reasonable or reasonably explained. So the EPA's methodology for determining the most cost-effective pollution reductions was based on the assumption that all 23 of the states that were under the FIP would be participating in it. And so after the rule was finalized, when all these states sued and the various lower courts began issuing stays and blocking the rule's enforcement in their jurisdictions, by the time the case actually reached the Supreme Court, only 11 of the states were fully operating under the federal implementation plan. So the EPA's calculation for what was cost effective for Ohio and Indiana was based on a 23-state model, but there were only 11 states now participating in the plan. So you can see how that creates quite the issue. Only a few of the states upwind are actually participating in it. So what's the point in actually following it? And the court found that was ultimately arbitrary and capricious and didn't have any reason to it, so they issued the stay. I talked to some of the folks at the Utah Division of Air Quality, and because the Trump administration's announced their actions, we're kind of in a state of limbo on the matter, and they're gonna restart the process, from my understanding. But I don't think this is going away. I mean, the Good Neighbor Authority is in the Clean Air Act. There's got to be something. The only way it could go away is if they increase the amount of ozone you could emit back into the atmosphere. So we'll see what the Trump administration does. They haven't given us any direction, but that would be my guess. And, you know, ozone's an interesting thing. We've heard it a lot in this meeting. A lot of it depends on environmental factors, how much it snows, and who knows if it's fair. But after reviewing this case, I know that the Clean Air Act envisions the system where the states all work together to regulate air quality, but I don't know how you can, if one state sues and gets taken out, I don't know how you can have a good neighbor plan without just having a nationwide FIP at this point, you know, a federal implementation plan, so that they all have to be on the same playing field, playing by the same rules. And so the only way that could really happen is if some of these states like California, New York, you know, some of these more, what's the word? I'll just say blue states or more have stricter plans than are even required by the federal government. So that's really the only way I foresee it working. It's been interesting to see. So that's all I've got. I'll take any questions at this time. And my colleague, Kathy Davis, here from the Attorney General's office, she's going to be talking about the Basin Railway case, so it'll be a lot more interesting than mine. But I'm interested to hear if any of you have any questions, and if not, I'll turn the time over to Kathy. Okay. Yep.
Do you find with FIP it was going along the lines of what Obamacare was, where all the states are kind of required to do the same thing and they're dependent on each other, and it kind of sets you up that if they can eventually do that, that it makes it to where everybody has to, and it's difficult to get rid of after that point when everybody's dependent on each other for these, what you call swaps or credits, right? It seems like that's kind of the language they keep using is swaps and credits. You could comment on that.
Yeah, I mean, like I said, the only way I see it making sense under the system they tried to propose is if, you know, they've got to just ultimately tell the states, like, this is what you got to do. And so it will end up being a mandate, unless some states are super strict on how much they allow to emit. I mean, people have got to understand there's got to be some level of emissions in the world we live in today, and not all emissions are necessarily bad. You know, we need some carbon and some of these emissions in the atmosphere. They feed plants, they do certain things, but and ozone in the Uinta Basin is naturally occurring. You know, even if there was no oil and gas, no manufacturing in the Uinta Basin, we'd have a certain level of high ozone out here. It's just the nature of the beast. So yeah, I foresee it kind of going a similar way as Obamacare, unless Congress acts to amend the Clean Air Act. But I mean, you saw the authority in my earlier slide here. That's how it reads exactly. And so the the FIP or the SIP has to prohibit certain emission activities, and it was broken down into like the states itself, but then also industries like cement plants had to have their own kind of treatment, and oil and gas has their own kind of treatment, and power plants have their own kind of treatment. So it's a tricky beast, you know, trying to calculate that and measure it. But did that answer your question? Okay. All right, I will turn the time over to Kathy then. The green one goes to the next slide.
How much time do I have left on this? I want to keep on schedule for you.
Go ahead and do your full presentation.
Okay. Okay, I'm Kathy Davis. I'm with the Utah Attorney General's office. I'm an Assistant Attorney General and the Section Director of the Public Lands Section of the AG's office. In that capacity, I direct and manage all of the federal court litigation that the state has against the federal government and a lot of NGOs. So 7-County Infrastructure Coalition versus Eagle County, Colorado. This is the map of the road that was selected to be the alternative that was selected. The Supreme Court says it's approximately 88 miles. The Surface Transportation Board said it was approximately 85 miles, so I went with the Supreme Court. The Surface Transportation Board ruling just basically said that in response to the objections of the Center for Biological Diversity, that they didn't have the authority to regulate operators who were outside of the project, and so the analysis that CBD wanted was not appropriate or warranted. This basically shows the adoption of the exemption from prior approval requirement and the mitigation requirements that the board put on the project regarding safety, topography, air quality, water, and the like. So CBD appealed the Surface Transportation Board's decision to the DC Circuit. Under the statute, the Circuit Court has jurisdiction rather than going through the District Court, so they went directly to the Circuit Court of Appeals. And the Circuit Court found that there were numerous NEPA violations under the EIS, including the failure to look at upstream or downstream effects, to take a hard look at wildfire risk, and to explain the lack of available information on safety and local accident risk. So the case was then, a petition for cert was filed, and I want to say I did not work on this case, although I followed it very closely. So, so I'm very interested in it, and it has a very large effect on what we do in our NEPA processes. So it was appealed to the Supreme Court, cert was granted, and there was a unanimous decision. The majority opinion was written by Judge Kavanaugh. He was supported by Chief Justice Roberts, Justices Thomas, Alito, and Barrett. Justice Sotomayor wrote the concurring opinion, and she was joined by Justices Kagan and Jackson. Judge Gorsuch recused himself from the case, so that's why it was an 8-0 ruling. So the holding of the Supreme Court was that the court didn't give the board the substantial deference that was required in NEPA cases. Basically, under NEPA, the agency has the discretion to determine what the content and the extent of the NEPA evaluation is going to be. And then the second major holding is that the court incorrectly interpreted NEPA to require the board to consider environmental effects of upstream or downstream effects. And the court had several quotes that I liked in here, so I just threw them in here. And these slides are going to be available to you. I've asked Matt and Bart to make them available to you. Basically, the court reaffirmed that NEPA was a procedural statute, and the court should review an agency's EIS to make sure that it addresses the environmental effects of the project at hand, not separate projects. And again, the court should allow substantial deference to the agency regarding the extent of the EIS. And they said that NEPA wasn't designed for judges to hamstring infrastructure and construction projects. Courts should and must defer to the informed discretion of the responsible federal agencies. Again, also, NEPA was not intended to give citizens a general opportunity to air their objections to proposed federal actions. And they can't enlist the federal courts to force compliance with NEPA or delay or block agency projects. The concurring opinion didn't like the majority opinion very much. They thought it went too far, but they agreed that the decision of the circuit court went too far in requiring examination of upstream or downstream effects. So Justice Sotomayor said that even a foreseeable environmental effect is outside NEPA's scope if the agency could not lawfully decide or modify or reject the proposed action. So the impacts of this case are quite large because downstream and upstream effects have been a real problem with regard to NEPA cases. In this case, the circuit court was requiring the agency to look at effects on populations in the Gulf where the oil was eventually going to be transported, so way downstream from where the project was. So several courts have already applied the case. The Ninth Circuit has done it in an oil and gas case. The DC Circuit has done it for a gas pipeline. And the District Court of New Jersey has done it for offshore wind projects. So the agency review impacts are that agencies are not required to analyze impacts remote in time and location, and the focus is on the proposed action, not potential downstream or upstream effects. And that gives the greater predictability for project development. So the Supreme Court reversed and remanded it to the DC Circuit to enter an opinion that was consistent with the Supreme Court opinion. So on remand, we now have briefs being filed arguing the extent of what the Supreme Court's decision means. So on June 30th, the mandate was issued. That's several months after the actual opinion was issued. So the mandate went back to and sent the case back to the circuit court. On July 22nd, the opposition motion was filed by the various NGOs. And then on August 8th, the Seven County Coalition filed their reply brief. So now the briefing process is complete in the circuit court. The argument of Eagle County in saying that the case should be, the Surface Transportation Board decision should still be vacated, is that the board's numerous violations of NEPA that were unrelated to upstream drilling or downstream refining effects were not properly presented by the coalition in its petition for cert, and were not reversed by the Supreme Court and not addressed by the Supreme Court decision. And accordingly, those NEPA failures still require the Surface Transportation Board decision to be vacated. Now, I've looked at this decision pretty carefully, and the Supreme Court, in all of the effects that were analyzed by the Surface Transportation Board, the Supreme Court talked about either upstream or downstream effects. So I don't think the argument is very valid, but it is nonetheless still pending in front of the circuit court. And this is important because the Forest Service has to issue another decision, and also there's a BIA permit that's out there too. And those actions are tiered to the analysis of the Surface Transportation Board and the biological opinion. And so the new decision also has to be tiered to the Surface Transportation Board's reissued decision. And that can't be released until the DC Circuit Court makes its ruling on whether the case is going to be remanded and vacated. So this has big effects for NEPA. Under the Fiscal Responsibility Act, there were certain deadlines that were imposed for EAs and EISs, and there were additional provisions that allowed applicants to pay an additional fee to expedite the process. Meanwhile, while this was pending, there was a case that was decided in the DC Court of Appeals called Marin Audubon Society versus Federal Aviation Administration that said that the CEQ regulations that govern NEPA processes were invalid and ultra vires or outside the scope of the CEQ's authority. That subsequently resulted in an executive order from President Trump directing the CEQ to rescind its NEPA regulations, and ultimately the CEQ rescinded its regulations on April 11th, 2025. And this means that each agency has to develop its own regulations that govern the NEPA process. CEQ doesn't control that process anymore. So the Department of Interior in July partially rescinded some of its regulations and then updated its handbook to provide for processes under NEPA. So by shifting the NEPA procedures to the handbook, the Department of Interior thinks that it's going to be more flexible. It provides for more streamlined reviews. It reduces the opportunity and time for public comment, focuses on internal processes that would determine if an action is subject to NEPA, how they conduct reviews and make informed decisions. And then there's an emphasis on efficiency. EAs now are supposed to be 75 pages and be done within 1 year. EISs are supposed to be 150 pages or 300 for complex projects and to be done in 2 years. Again, there's payment for expedited review. The expedited timeline is 180 days for an EA and 1 year for an EIS. Because of President Trump's emergency order on energy, there are also alternative timelines for energy projects. EAs are supposed to be done in 14 days, and EISs are supposed to be done in 28 days. And it provides for informal, expedited, endangered species Section 7 consultation and alternative procedures for Section 106 compliance under the National Historic Preservation Act. And then in addition to that, there's a bipartisan bill that has been proposed called the SPEED Act, the Standardized Permitting and Expediting Economic Development Act, that is to simplify the NEPA process, defining what a major federal action is, establish judicial review limitations, including a 150-day deadline for filing any claims objecting to an EIS or an EA. That was introduced in July by House Committee Chair on Natural Resources, Bruce Westerman, and Representative Jared Golden, Democrat. Major federal action is defined as requiring complete federal control. You can't look at funding alone. Just because the federal government gives some money doesn't mean that it's automatically subject to NEPA. It exempts certain agricultural loans and clarifies what federal grants would be subject to NEPA. So even though this case was an incredibly important case with regard to NEPA, and it's very important to what we do and what the Attorney General's office does in representing PLIPCO, the case is still ongoing. So we still have questions on what's going to happen with the decision with the Circuit Court of Appeals, and then subsequently what happens once it goes from the Circuit Court down back to the Surface Transportation Board. So with that, do you have any questions?
So I thought I heard yesterday, Dave, when's the decision expected? I thought it was coming up.
Well, I don't know that I don't know when the decision is expected. We hope it's soon. It's been pending for a while, but courts don't have a deadline for issuing decisions. I would be glad to know that it was coming up.
I've just heard early soon, like next.
I believe it will be soon, but there is no deadline on the court. Okay. Anything else? Okay. Thank you very much.
I had the pleasure, I was going to say a little bit about John, our next presenter. I've worked with him quite a bit, not only in the field. Him and I have been out and about, and he's with the UIC program. And so I got to spend a lot of time out in the field with John, and I got to realize he's super passionate about what he does, and he's very knowledgeable with underground injection control. Worked with him in the office a little bit as well behind the scenes, so just happy that we have John with us today. We'll bring him up. He is again with the Division of Oil, Gas, and Mining with the UIC program.
Okay, I'm glad to be here. I know a lot of people probably had an early morning. I'm the solution for your insomnia here today, so look forward to telling you a little bit about underground injection control. And my boss is behind me, so he'll get to clean up all the mess that I'm going to make here in the next 20 minutes or so. Ultimately, my hope is that by the time I'm done with this presentation, you have an understanding of what our role is in underground injection control, and our primary concern is to protect underground sources of drinking water. So I'm going to just walk through a little bit of the history of Class 2 underground injection control in the state of Utah. This diagram is on our website for oil, gas, and mining. If you go in here, you can see the different classes of underground injection control. And Richard will talk a little bit about Class 6, and that's a big hot topic these days. My world is just the Class 2. So I'm worried about, or I work through permits and regulation of underground injection for oil and gas related activities. So going back to the 1930s, injection was happening. It was mostly for disposal, but there was operators were realizing the benefits of utilizing water and gases to enhance their oil recovery. And so it was just kind of a Wild West time. People just did it because they could, and there was really not much regulation on it. So then in 1974, with the advent of the Safe Drinking Water Act, the EPA was established as the regulatory authority for making sure that the environment was being protected. And at that time, there were 5 classes of injection, which included Class 2, so regulating oil and gas-related injection. And the standards were formalized in 1980. In 1982, the state of Utah applied for primacy for Class 2 so that we would have that oversight for Class 2 underground injection control. In 1983, the Groundwater Protection Council was established, and they've been a great organization for kind of being a sound of reason and making sure that the policies are what they ought to be for protecting the environment. So in 1981 was actually when the MOU was sent. It provided responsibility outline. The official application was sent to the EPA in 1981. The primacy effective date became January 30th, 1982, and we've had that primacy ever since. I'll kind of gloss over these other points, but the program description outlined how the division, how the state would regulate UIC. It talked about funding, where we get our funding from for running the program, and as that third bullet point there at the bottom about our primary role is to protect underground sources of drinking water. So just some more timelines here. Under Governor Matheson's administration in the state, we rolled forward and had and continue to work with the EPA to make sure that they are the ultimate authority, but they've granted us primacy to control UIC in the state of Utah for Class 2 wells. I guess I kind of glossed over it before, but the Department of Health was originally part of that, and the DEQ now runs some of the other classes of underground injection control. But we have authority for Class 2. So just talk a little bit about this. I know we have a fairly varied audience here. I know a lot of people are in the operator role, but just want to kind of touch a little bit about well construction and how it relates to underground injection control. So, and I'm just going to go in a generic sense, you know, through the history of Class 2, for saltwater disposal especially, wells were converted to disposal. They were old producing wells that had kind of run their life, and now they either needed to be plugged and abandoned or used for some other purpose. And to dispose of wastewater associated with production, they needed to, it became favorable to convert wells to injection. So in the diagram, as you can see here, I've just kind of highlighted it toward the bottom. We have surface casing, which can be at whatever depth. We usually have a long string or a production string of casing that goes down to where production happened, or where, in cases lately, we've had purpose-built injection wells drilled. They go down to a target interval, and the little yellow dashes show where the perforations are. We have a packer set in the casing, and then we inject water down the tubing, and it goes into those perforations and into an underground reservoir. So one of the requirements we have in our construction of UIC wells is that packer can be at most 100 feet above where our perforations are. So just kind of give especially the layperson maybe just a little bit of a background of what well construction looks like for a UIC well. So what do we do? How are we protecting underground sources of drinking water? Right now, we have a total of 89 saltwater disposal wells in the state. We have 719 enhanced oil recovery wells. So those are injecting water or CO2 into reservoirs to try to increase the recovery of oil in reservoirs. And then there's also very interesting and fascinating, there's salt caverns down in Millard County that are storage of various materials. And when they fit in our world, we regulate them under DOGM. And if there are other substances, they're regulated by DEQ. And the point I want to make here, this bottom bullet point, is that every injection well has the potential to threaten an underground source of drinking water. So whatever it may be, whatever substance it might be, our purpose and our goal is to protect that potential underground source of drinking water. So as we review permit applications, we're very methodical to make sure we follow our rules, make sure we're using common sense and reviewing applications. We've recently engaged in switching our platform for for submission and review of UIC applications. We're using Salesforce, and I'll talk a little bit about that in a second. The onus is on the operator to make sure that their application is complete. It works out better for both sides. I assure you that I don't want to be spinning my wheels and sending stuff back. And so it's nice when the application's complete prior to submittal. And we, as I've mentioned, we systematically walk through our R649-5 rules, which govern how Class 2 UIC wells are constructed and operated. So as just an example, we have this crosswalk we go through. So Rule R649-5-2.6 says that the operator needs to submit a copy of a log of a representative well completed in the pool. I go through, is that adequate, not adequate? I make a comment. If it's not, it gets sent back to the applicant. Okay, so I'm just gonna kind of walk through what that process looks like from a grander scale. This is a very busy slide, so you're not gonna be quizzed on it later. You don't need to, take great notes. I'm just going to kind of walk through some of the different components of this as we go. So the first little part here on the left is that we get an application come in. So I've got to kind of make sure that all the ground's set, everything is ready for me to review. So I'm not going to go get into the weeds on this, but the very first thing I do is check to see if the well is in Indian country. If it's in Indian country, I'm done. It goes to the EPA. We have no jurisdiction over wells in Indian country for UIC Class 2. I check to make sure that the application is full and complete. Then the next one is really a big one. It's become a big one recently. A few applications have come in where it's a very in-depth area of review, or AOR review for me. We have a half-mile radius from the injection well to make sure that there's mechanical integrity and that there's no risk for water to be injected and make its way to an adjacent well, a nearby well, and contaminate an aquifer above or below the injection zone. And so I'm a geologist, and so I spend a lot of time looking at the geology as well. I look at the cross sections and what's going on geologically near that injection well. And if there's reason for an aquifer exemption, which again won't get into the weeds there, but if the connate water in the reservoir is under 10,000 parts per million TDS, then it would require an aquifer exemption, and that prolongs the process a little bit. We have to get it out, get that worked out through the EPA to make sure we get that aquifer exemption. So if all these things pan out, then we send out what's called a notice of agency action, or an NAA, and it goes out to the Salt Lake Tribune and a newspaper of local circulation in the county where the well is being proposed. And then the operator and other agencies, including the EPA, get copies of that notice. So I just want to kind of talk about the area of review a little bit. So just a little cartoon here, but the center well there in the circle would be a UIC well, and any well that's within that half-mile radius must be reviewed for mechanical integrity, and anything outside of that is outside of the area of review, obviously. So what we're doing is we're looking for verification of cement bonding, and of course some of the operators in here are familiar with cement bond logs. Just on a general sense, it's a tool that goes through the well after it's been cased and cemented, and it can detect how well that casing got cemented to the formation and how impervious that might be for, it gives us at least an indication of how impervious that might be for fluids that get injected and prevention of migration of the fluids up or down the wellbore. So it's not only important for that specific well that we're injecting into, but it's also important for any well nearby. Over time, that plume of injectate will make its way to another wellbore. Are we protected? And we're not going to allow water to migrate along that wellbore and contaminate a different layer that we want to protect. So there's just an example of a cement bond log. I won't get into details of interpretation, but that's what we look at for all those wells within the area of review. Okay, so the next step is the comment period. So we have a 30-day comment period in which anybody can object or comment on that notice that's gone out for that well. So if no comment comes in, great. If there is a comment that comes in, we work with whatever their objection is or whatever the comment is, to see if they want to bring it before the board or how serious that objection is. If and when that's all been resolved, then we proceed with what's called an approval to convert. And so we now grant, so no operations can be done on that well until we've granted this approval to convert. And so what does that approval to convert look like? We send a document to the operator, say, okay, we've passed the comment period, we're good, you're ready to move forward. They will need to submit their plan of what they want to do, and we'll review that plan and approve it, or work with them to make sure it meets what we want done in the wellbore. And it also includes their plan for a step rate test, and I'll talk about that here in a second. As I note there at the bottom, we have field staff within the UIC team. There's one here in the Uinta Basin and one that covers the southern part of the state, and we want to make sure that our staff oh yeah, I didn't see Mark come in. We got both of our field inspectors here, but we want to make sure that we're there to witness some of these operations. So we require them to give us advance notice for when they're going to run these operations. So they'll convert the well, and I'll talk about that here in a little bit. So that's this next step in the flow chart. So what they need to do, the operators in the well, they need to plug back whatever deeper horizons might have been productive but are not where they want to inject the water. Then they'll go in and perforate at the depths that they've proposed in their application. If necessary, they'll swab a water sample so we know whether it's less than 10,000 parts per million, make sure that it's an interval that we don't mind injecting into. They'll need to set their tubing and packer as they've described in their operations, and back to that cartoon diagram that I showed. And then they'll run their step rate test. So we ask operators, it's not required, but we ask them to run downhole gauges for their step rate test so that we actually measure the pressure rather than calculate. And I've spent I'm not an engineer. I do have an associate's of engineering, but I can't stand working on equations for guessing what friction loss is. So we like having actual data and not calculating data. So they'll also need to verify the integrity of their packer, make sure there's nothing leaking in the packer or in the casing above the packer, and they'll run their step rate test. And like I said, in my time with the division, we've witnessed every step rate test. It's nice to be out there and just make sure that what's going on. And then the operator submits their step rate test data. So the next block here. What we've done recently is we've created a standardized, some of you may have submitted step rate test data to me in the past. We kind of standardized what we want from you. So we ask you to fill these charts out. They're available on our website, these forms. And so some of that information is things that we can do to calculate the friction loss, but anyway, we use these for calculating the maximum allowable injection pressure for those wells. So some details about the step rate test. What happens is, for those of you unfamiliar with it, it's, as I said, that top bullet point, that this is what we use to determine what pressure we will allow the operator to inject into their wellbore. So the procedure has to be approved by us. Each step must be a minimum of 15 minutes. So they're going to be injecting at a constant rate for 15 minutes. And each step, so it'll be 15 minutes at one rate, and then they'll bump up to a different rate. And I don't care what the step is, whether it's 8 barrels a minute or a half barrel a minute or 20 barrels a minute, doesn't matter. Just every step through the test needs to be the same step. And then they'll hold that. Usually it's rate. I haven't been on any where we just held pressure constant, but it'll be the same rate or pressure for that, for the duration of that entire step. And we would like to see 7 steps total in the test. And I've got an example here I'll show in a second. Yeah, I've already covered that. Probably plenty about the downhole gauges. They're very nice to have. We've had some operators that have run the downhole gauges, and they've got the surface pressure gauges, and it's been really cool to see that empirical data to kind of see what the friction loss has been in these wellbores. So this is what a chart looks like when we evaluate the step rate test data. The early part of the test is the the data point's on the left, the latter part of the test is on the right. And what happens is when we reach the parting pressure in the wellbore, when we're actually fracturing the rock, is where that those two lines intersect, and that becomes our maximum allowable injection pressure. That's what gets written on the permit. That's what you're allowed to inject up to. So I just want to touch base real quick about the new Salesforce application that we have for applying for and reviewing UIC permit applications. This is our homepage for those applications. You click on apply for a permit. It brings up this page. You go to UIC well and injection well permit. Over to the right side, you say apply, and you go through a very detailed process for your application. Before you'll be able to access that, you need to reach out to us, and we'll give you credentials to get into the system, and you'll just go through. They'll prompt you for all the entries that you need to put in there, and then we just go through that process that I've gone through with that flow chart. So once the operator receives that permit, some of the guidelines they need to follow, that there's conditions that we put on the permit. You must X, Y, and Z. And then every other condition for operating a well in the state of Utah still needs to be met. If there's any spills, you need to report them, maintain a field presence, monitor the equipment. With injection wells, you need to report the injection volumes and pressures on a monthly basis. And our UIC field team are these two guys that work with me, and Richard and I will go out on specified intervals for the different wells and do inspections. And every 5 years, every injection well in the state needs to perform a mechanical integrity test. So, and then we also, we have these, charts. We track our inspection data very closely, and we try to make sure that we're staying on target. We have done a great job on the MITs, especially. We make sure that those 5-year MITs happen. And then also any time that an operator goes into a wellbore on a workover, especially anytime they're going to move a packer, we require an MIT before they resume injection in that well. Make sure that we're not risking any kind of contamination. So I just want to touch on some resources. Our website, we try to keep it up to date. I think it's in pretty good shape. There's a lot of resources there for UIC wells. There's guidance documents, SOPs on applications, and so forth. Our Data Explorer site is very useful. I use it all the time in reviewing permits, so I think it's a valuable resource for the operators as well. And one of the things, I don't know, I feel like, I'm maybe a little jaded, but I feel like our division, the Division of Oil, Gas, and Mining across the board, has a good relationship with other regulators and operators. Maybe I'm wrong. Somebody, correct me when we're out here having snacks or whatever, but we pride ourselves. We've had a great relationship with engineers and whoever from the operator side. We like to be helpful for you guys. One thing that we're working on right now is, I've got it here in the summary slide, but one of the things we're working on is revising our rules a little bit, because the way the rules were written in the 80s, people were just converting wells, and now we've got a lot of operators that are doing these massive frac jobs and so forth, and they want to drill these purpose-built injection wells. We're trying to help get that 30-day comment period done before you've got capital in the ground, hoping, crossing your fingers that some psycho with a lot of money that can hold things up in a comment period or whatever, keep you from having those stranded assets and stuff like that. So just in summary, I want to point out or remind you, our primary purpose is to protect USDWs. We take that very seriously. We try to, we review those mechanical integrities. I've rejected a handful of applications recently because I was concerned about the mechanical integrity within the area of review. We're not going to compromise our standards on those things. As I said, I really enjoy the discussions that we have with operators. I'm happy to, I want to be a resource and be helpful for you. I was on the consulting and operating side for 17 years, so I kind of, I get that side of it. We're working on revising the rules, as I mentioned, and we're excited about the new software that we're using. So, oh, I finished right at 25 minutes, so I guess there's no time for questions. But no, I'm happy to answer any questions for a minute, if there's any out here. Yeah. Wait for the mic, will you, so the online people can hear it. I don't think it's coming through. Maybe try it again.
Okay.
There we go.
Yeah. Do you have an SOP for water treatment?
Water
for the-
treatment, that's not part of our world. I don't have that. And I don't know if Bart or somebody else has a comment on that, but yeah, as far as water treatment, I'm just in the injection world. Yeah. Oh, treating the injection water. Okay. So just to rephrase the question, it was about the treated water and incompatibilities, maybe, or concerns with biogenic. Yeah. So we do, as part of our review process, we review what the injection water is and what the connate water is, and we look for compatibility there. And we require an analysis of the injection water and the connate water, and so that should be addressed in the.
So you don't have H2S coming out in your taro, in your enhanced recovery?
I don't know on that. Do you know, Richard?
We don't have a specific written guideline.
Is it okay? Any other questions? Okay, thank you.
Great job, John. Thank you. There's so much to that, and which is partly why our next presenter still sticking with the UIC program. Richard's done a great job. He took the bull by the horns a few years ago, and he has been running with this and has a great team underneath him. So Richard is here today with Class 6 Geological Carbon Sequestration Primacy. Richard Powell, also with the Division of Oil, Gas, and Mining.
Okay, thank you. I just wanted to comment, John, I really appreciated your presentation. That was really good. I live in this world, so I was, kind of following it closely. It may have been parts of it others that weren't exciting, but I thought great job. And just comment on John. John came to the division here about 2 years ago with just fantastic credentials in geology and his work in industry with reservoir work, and he's just been a great addition to the Division of Oil, Gas, and Mining. I'm trying to figure out how to adjust this stand.
Richard, you can leave it there.
Okay. All right. So today what I would like to talk about is Class 6. John gave you a pretty good overview of Class 2. Class 6 is another UIC well category. I've talked about this a little bit in the past, but what I've found is that generally I need to speak and back up a little bit and explain some of the basics of just what we're doing. So what we're seeking, John spoke about primacy for Class 2 wells. What we're seeking right now is primacy for Class 6 wells. So what is primacy? And primacy basically is the regulatory authority granted to us from the EPA so that we can oversee the program. Until EPA says, state, we have an agreement, you look at you do this program, you regulate it, we can't regulate it. So we're looking at Class 6. A couple of things about that. We've been working on it a couple years. What prompted this? Our House Bill 204 from the 2022 legislative session is now Utah Code 4011. That gives the Division of Oil, Gas, and Mining, the Board of Oil, Gas, and Mining, a mandate to go after this Class 6 primacy. And so for the last 2 years, we've been working pretty hard on that. The EPA, again, like I said, oversees, they're the primary authority on this. The Safe Drinking Water Act created the need for this UIC, underground injection control programs. And so when we get authority, it comes from the EPA, and just as a reminder, Indian country, this will be just like, for you operators, you're well aware of this, if it's in Indian country, again, EPA will retain the authority there. So just a little bit of background about kind of some other things that are going on in the country. Currently there are 4 states that have Class 6 primacy: North Dakota, Wyoming, Louisiana, and West Virginia. West Virginia just got their primacy this year. So it's kind of a slow thing. There's many states that are kind of in the hunt, like, so to speak, like we are. And so far, only 4 have gotten across the finish line. Arizona and Texas have applications in, and they're probably a little farther around. There's a couple other states, Colorado, they're really close. So is Alaska is actually really close too. Arizona seems to be a little bit different. I kind of feel like they've put the cart in front of the horse a little bit, because they seem to have the application in with the EPA prior to having total state approval. We went about it a little bit differently. Other states, you'll see from this, there's not a whole lot of Class 6 permits around the country. There's 32 issued permits that I'm aware of, and many of those are in states that aren't even seeking primacy. So a lot of the pending applications are in states like Illinois and some others you can see there. California, there's a number of things going on there, but those would be EPA issued permits. So Class 2 or Class 6, often I get this question. There's a lot of Class 2 wells out there, and there's 45Q tax credits, which are very incentivizing for injection. So we often get presented with this idea. Well, what can I get away with? Putting CO2 into the ground and into a Class 2 well, and so that we can qualify for tax credits. So these are just some of the kind of the definitions here. A Class 2 well is for the disposal of fluids that are brought to the surface in connection with conventional oil or natural gas production, and that may be commingled with wastewater produced from the operation of a gas plant. So, and then the second part of that is enhanced oil or gas recovery. These are clearly Class 2 functions. If the well is to support that, directly the conventional oil and natural gas production, then it qualifies for a Class 2. And so what we're looking at, I'm often posed with this question, about different projects. And basically the bottom line is, if you meet the definition, if you can meet this definition of a Class 2, then it can be a Class 2 well. Otherwise, not. The source, it gets fairly complicated in that if you are going to just inject CO2, for storage, then that can't be done in a class 2 well unless it has to do with, unless it's supporting production of oil and gas. If a well was, if your source is from a point source like a power plant, that CO2 could be used, could not be just stored in a class 2 well, but it could be used for enhanced oil recovery in a class 2 well. So, and what we're talking about, a couple of other terms that I just thought were important to understand, what a class 6 well is. It's for the sequestration of carbon dioxide, meaning the long-term storage of that carbon dioxide in a deep saline formation. And then, and as far as a facility, I thought that's an important definition. When we do have class 6 authority to regulate, our permits will be based around a facility. And the wells will be part of a rural view, but you'll get a facility permit. So just a few things about the Class 6 program, basically kind of notable things. Class 6 are, like I said, for the injection of CO2 into these deep rock formations for long-term storage. The rule has to be just as stringent as the federal rule. And so for 2 years, we've been working on getting this over the finish line, the rule, and we're kind of reaching the final stretches of our application process. But the rule is kind of complicated. It's stringent. It's a 43-page rule. In Utah, our Class 6 program will be fee-based. It's going to be a little bit different than anything you're used to in the oil and gas industry, because in the division of oil, gas, mining, on the mining side, there's fee-based programs, but not on oil and gas. This will be entirely fee-based. And then 45Q tax credits. I talked about them just a little bit about that. 45 tax credits are kind of the primary motivation. I was at a conference last year in North Dakota, and there were a bunch of projects, a bunch of industry folks who were talking about their projects. And every one of them made the statement that without the 45Q tax credit, the project would not be even being considered. So that's a big thing. So that's the primary motivation so far is tax credits. Right here, under the whole 45Q tax credit originally came from the Inflation Reduction Act from back in 2022. And so it created a parameter where if you have dedicated storage, the tax credit is $85 a ton, and that would be from a direct capture from a point source, say a power plant. If you direct air captured, meaning you put out a big, just pull in CO2 from the air, then it was a higher tax credit amount. Under the Trump administration and the One Big Beautiful bill, this has been changed. So now there's parity between dedicated storage and associated storage. So by associated storage, what we're talking about is CO2 being stored during the process of EOR. So, right, we're injecting CO2 to help with enhanced oil recovery. Some of that CO2 ends up being sequestered. Okay, so that's generally what associated storage is referring to. So those have been equalized. So now, if you inject, for CO2 for EOR, that tax credit is now $85 a ton, which is, equal to what it was before. So quite a big change under the new administration. That really, let me go back to that just a second. But, I believe this is a way that the administration wanted to incentivize that use, which they viewed as more of a beneficial use, EOR versus just sequestration. So why is the Division of Oil, Gas, and Mining seeking primacy? Okay, so first of all, I just want to make it pointed out that as a division, we take no position on climate change or you know, the merits of carbon sequestration and any of this. We're not making, the Division of Oil, Gas, and Mining, the state is not seeking primacy of Class 6 out of concern for global warming or anything. It's not a political thing. But the fact is that CCUS is used to reduce CO2 emissions to the atmosphere. And so the legislature felt that the future is going to involve injection of carbon dioxide. And we want to have the regulatory authority over those wells and run that program. There's a few things that we can do that. The oil and gas, the Division of Oil, Gas, and Mining is well equipped to handle this because carbon sequestration wells are constructed very similarly to oil and gas wells, and that's really where our expertise lies, is in permitting and operating, you know, overseeing those types of wells. And there's some other things. The federal government, the EPA, is the permitting time frames have been fairly long, up to 6 years. And so we feel that we would be in line with other states, which are averaging around 10 months to review a Class 6 permit. And just, you know, I think we bring a little bit better oversight, local relationships and stuff, and we can hopefully bring some cost savings through more certainty, industry certainty to operators. So I wanted to show this. We've been on this quest, and it's felt very long and arduous so far, this quest to, you know, get a 43-page rule over the hurdle and stuff. And so what I wanted to point out to you, this is directly from the Utah Administrative Rules website. There it is, R644. It's approved. So, you know, it's kind of neat to see that, because that's the first big, you know, this is the big major hurdle that we've gotten over in this process. So it's kind of cool. And I would just mention that there's been a few people just instrumental in this process. They're not here. Well, John has helped, but Natasha Bailiff and Andrew Haynes, our attorney, have just been fantastic in this whole process. This has been a lot of hard work and a lot of back and forth with the EPA, a lot of comments that have had to be answered, and we submit documents to the EPA and they come back with comments, and we've been in this process for 2 years of drafting this rule and finally getting it to this point. So basically, here's the status. We have had a stakeholder comment period open. We've gone through 2 rounds of EPA reviews with Region 8 with the rule. There's other documents too that have been under review, and still are. We're still in negotiations on a couple of things. The rule has now been adopted. That was as of July 30th, 2025. These other things here, primacy application elements, these are all the parts that have to be submitted in a primacy application. And so the rule is gone. Like I said, we've gone through debate and back and forth. The EPA has accepted our rule. Now the state has accepted the rule, so we're good there. We've got a federal state regulation crosswalk, which is basically a detailed table which illustrates how our rule meets all the stringency requirements of the federal rule. And so there was quite a bit of back and forth with that. The state of Utah likes certain language, and we had and the federal government likes some different language, and so there was a lot of back and forth, to get that acceptable. Program description, that's well, it's just a fairly lengthy document that shows we've created forms and the processes and the kind of the whole structure of how our program will work. And so that's another thing that's gone through a review with the EPA and been accepted by them. An MOU, we had to we had to enter an agreement with DEQ because they oversee other parts of UIC programs. So we're there. We've entered into that, or tentatively have an agreement there. MOA with the EPA. This is somewhere a little bit of a roadblock right at the moment, where we're kind of having some back and forth on some language that's in that memorandum of agreement with the EPA, and we have some things we're trying to make sure we get cleared up before that moves forward. The governor has to send a letter that says, hey, we want this program. And so the governor's office and his legal staff they've had these documents and under review for a little while. Same with the attorney general. Our attorney general has to send a statement declaring our capability and enforcement authority to be able to operate and regulate this program. And then there's more. We've already gone through 2 comment periods, one through the state rulemaking process and one earlier in the drafting process. As soon as we have the application completely finished, we'll have to go through another another 30-day comment period and hearing for public. So that's still up in the future. But those are basically it. So we're getting really close to kind of finalizing our application, and we'll have it submitted after this next comment period. Now, the following slides, I don't know, I've got some of the fundamentals of how our system will work, how this program works. I'm not going to get much into this, and I think, when is my time supposed to run out? Is everybody, not everybody's, right now, okay. So I'm not going to go into the fundamentals of our system too much. It's a complicated rule, and so there's a lot of things. John showed you just an example. John showed you a picture that showed an area review that was just a simple half-mile radius. With a Class 6 well, it's not so simple. It's based on computational modeling, pressure fronts and injection volumes and that sort of thing. And so the area of review will be kind of dynamic based on the inputs of the computational modeling and what we put in there. So there's a lot of those kind of complexities. There can be 5 years or up to 50 years of post-closure monitoring on these wells. So there's a lot of things, the fees. And so what I'd like to just say is anybody, if you have any questions about it and you want more of the kind of nuts and bolts of what the Class 6 program and what our, the regulatory framework will look like, just get with me after and ask, and I can help you. But I'll close right there if there's any questions. All right.
Disappointed. I thought you guys would get him. Maybe next time. Get him in the halls. Great job, Richard. There's so much to that stuff. These guys do exceptional work behind the scenes. Lots of time and hours put into it. So thank you to the entire UIC group. Moving forward, we have Travis Campbell with us with Uinta County with the Uinta Basin Energy Summit update.
Good morning, everybody. I'm Travis Campbell with Uinta County Economic Development. I'm just Going to say a few quick words on the annual Uinta Basin Energy Summit. This is something we're happy in Uinta County, we're happy to put on every year, which this year will take place on Wednesday, September 24th through Thursday, September 25th in Vernal at the Uinta Conference Center. Coming from the Economic Development Office, we understand how important the oil and gas industry is, which is why we are so happy to put this event on and really just show some support to the industry and to oil and gas and all that you all do. I think this event's always great because it brings together so many in the industry, so many policymakers, and just the general public who has interest in oil and gas into one place to hear updates and to network and collaborate. And similar to years past, this year's conference will be a two-day event. It'll be full of different presentations from roughly 50 individual presenters. We'll cover a couple dozen different topics. So it'll be a packed couple days, and we'll cover, we'll have discussions on with both petroleum and natural gas producers. We'll have updates from individuals on local projects like the Uinta Basin Railway. We'll feature details on that 7-county Supreme Court case and what that means for Utah, but also really what that means for NEPA nationally. We'll have discussions on current litigation and other cases and the outlooks from those cases and the possible impacts to industry. We'll hear from researchers research being conducted in energy development in the state. We'll have legislative updates from our state officials and our federal delegation, and updates just from all of our various state and federal regulatory offices. So while the agenda is not, it's mostly complete, but we are still working on a few additional items to make sure that the agenda is as robust and detailed and timely as possible. And then in addition to all those presentations, we'll have plenty of networking opportunities. Like I said, that's one of the best benefits from this event, is just bringing everybody together and making sure that there is space in the conference center to have those individual conversations, to network, to collaborate, and to take advantage of being there together. I think I've got, you can kind of see, I mean, the slides, the graphs are kind of small, but as you can kind of see on that graph on your left, the crowd continues to grow year after year at the Energy Summit. You may wonder why those flat lines are there. Those were just the years that we had the Energy Summit in August, so the dates were moved back further. But we're anticipating around 500 individuals this year. So again, just similar to years past, but we're just growing a little bit each year. You can also see from that heat map that our interest is not just locally, it's not just here in Utah, but we get attendees from Utah, we get regional attendance, we get national attendance. So I think that just shows you the interest in Utah's industry and what's happening with oil and gas here around the country. So I can't not be up here and mention the sponsorship opportunities. We do have sponsorship opportunities available. We still have some of those open. If you're interested, I'd be happy to get with you and talk about the benefits and what the different levels offer for our sponsors, but just how important our sponsors are. So preemptively, thank you to those who are sponsors and have sponsored in the past. And then lastly, something new this year that we're calling the Basin Burner. This is something that's been requested of me for a few years, so we're finally doing it this year, but we are going to kick off the Energy Summit with a golf tournament. So if you're looking for a reason to take off a Tuesday, this is a very valid excuse. So Lori in the back, if Nate comes to you and says he needs Tuesday off, you're going to know why. But it will be Tuesday to kick off the summit. This is a really traditional 4-man scramble. We will have whole prizes. We'll have prizes for our winners. We'll have good food, good networking opportunities with our whole sponsors. Just another way to bring folks together and have a good time while you're in town for the summit. And then after the golf, the golf course will be welcoming golfers and Energy Summit attendees to a reception, which is being hosted by Summit Energy. So shout out to Reed Page and his team for sponsoring that event. That'll just be another good opportunity to get together to talk and enjoy some time together. So all in all, we're looking at another good Energy Summit this year. It's coming up in about a month, so we are getting close. So if you have questions, if there's anything I can do for you, to make sure you know what's happening at the summit. Get with me, let me know. Big thanks to the Uinta County Commission and Duchesne County Commission for really helping put this together and make this possible. Got to give a big thanks to the Uinta Conference Center and their staff because they always do such an amazing and very professional job giving us a good venue and a good conference. Ricky's not here, but got to give Ricky and UPA a big shout out for all that they do to help coordinate the speakers and put these topics together. And of course, all of our participants, like I said, we've got roughly 50 individuals presenting this year, so big thank you to them, and of course all of our sponsors who make this possible. Big thank you to everybody who makes this a good event year after year. If you have questions, again, get with me. You can visit basinenergysummit.com to learn more about the summit, to see the detailed agenda. You can watch past presentations from previous years, and that's where you can go to register. So again, let me know if you have any questions, but thanks for your time. Talk to me if there's anything I can do for you.
It's that time. Let's have the morning break. We'll come back. Let's be back in by 11. That gives us a good 20 plus minutes or whatever to mingle. So come back by 11.
Check, check.
Check, check. Well done, Alan. That prompts me right into it. I love it. He says, you're late. Well, you're right. Way to make a statement that I can't argue with. If we can get everybody to kind of file back in, anybody out in the halls, if you guys can tell everybody to come back in. That is the worst part of doing this. You interrupt all these conversations that are super valuable, and I recognize it. So I'm going to awkwardly stand here for a few minutes while we get a couple more from the halls to come back in. And it's hard when you're presenting the next one to have everybody interrupting what you're doing, so hopefully we can get them to move. Well, that's what we're going to have to deal with. We'll just move forward. They'll trickle in as we move on. And I held that not only for our next presenter a little bit, but what I'm touching on here is a huge deal. Big thanks to Melissa Hughes. Melissa Hughes is a little bit behind the scenes with the logistics, along with Deborah Heron. These ladies do so much to make this work behind the scenes. So big thank you to them. The Duchesne and Uinta County Commissioners are here. We thank those guys for coming out, those individuals, as well as Senator Winterton is here in attendance as well. So thank you to some of the people. Thank you to everybody, obviously. The list could go on through each and every one of us, but we wanted to highlight those few. Also, the morning break and snacks was courtesy of Duchesne County. Make sure we really thank those members when we see them. Duchesne County does a whole bunch and makes this work really great for us. The one that I feel terrible about that I didn't start off with is the man in the back. Matt Morgan puts this together and doesn't just put it together, but he does it with excellence. And the job that Matt does, I agree. A round of applause for Matt. It is unbelievable. Thank you. And I had a thought, I didn't want to go on forever, but I will touch on it. While we were all at home with our families last night, Matt was here setting this up. I mean, he does this stuff, you know, the night before to make sure everything's ready to go. So he's a guy that does an excellent job at what he does. Moving forward, let's go on with our next presenter. We're going to have with a BLM update. Jerry Kinska is here from the Vernal Field Office with BLM. Thank you.
Okay, I'm Jerry Kinska. I'm the Assistant Field Manager over Lands and Minerals out of the Vernal Field Office. Most of you, I think, know who I am, but so Bart approached me a while back about if I'd be willing to talk about what we've experienced with this administration change since then. And I don't have any slides prepared, but we are working on some of what you'll hear today. We will have a presentation at the Energy Summit, and that'll be covered there again as well. So every administration brings change. We have different policies, different procedures, different outlooks. So but for part of what's affected us is, and I'll start with some staffing stuff, which I think was a lot of the interest. So since the change of administration, within the Green River District, which is the Vernal Field Office, the Price Field Office, and of course the district staff. Price Field Office covers Carbon and Emery County. We're down about 20 positions overall since then. The first impact with the change in administration affected they were called probationary employees within first year of employment, regardless of, that would include positions that you just got selected for, even though you may have worked for an agency for some number of years. So in Vernal, I was only aware of 2 probationary employees, and we went through a waiver process where we didn't lose any of those employees. Elsewhere without the Bureau, there were employees lost. So since then, there's been several other opportunities for folks to take early outs, and my staff, the Lands and Realty, or the Minerals and Realty staff, we've lost 3 employees. So a petroleum engineer, a realty specialist, and a land law examiner. And we haven't been able to move forward to fill any of those yet. There is a hiring process, or hiring freeze still in place. That's been extended into October. We can go through a process to, call it a waiver process, to request being able to advertise and try to fill a position. Every state competes for those positions. I think I only know and this does not include the fire positions, but I only know of 2 positions in the district that have been filled. One's our supervisory law enforcement officer, and then recently there was a selection for a safety position. So from a minerals and land staff, it's been not as great for Vernal compared to other offices in Utah. But we also could have, there are people that took jobs elsewhere in the state, and they got caught up in their transfer was going to occur over this administration change, and those transfers have been canceled. So it could have been a bigger impact than what it's been so far. So that's the impact we've had staffing-wise, at least for Vernal. What we don't know is there's still plans out there that may include additional reductions in staff. We just don't know what those plans are yet. So it could be more to come. So that's, unless there's, anybody got questions on any of that you want to try to ask at this time? Not that I may not have answers, but that's the impacts we've seen. So from a workload standpoint, well, let me talk about one other thing really quickly as well. So part of the change in administration was they pulled back for certain things our delegation of authority to approve projects. The one that affected Vernal the most at the time was a pipeline project, the Green River project for Kinder Morgan. It's approved, but we went through a lot of conversations with the Interior Department and whoever on who was going to approve the project. So finally, they amended the delegation of authority process, so we were able to do it locally. But the Biden administration had the same thing for the first 60 days. This administration had the same thing for just different projects that were involved. One notable difference was in the Biden administration, BLM couldn't approve any APDs without Interior approval for the first 60 days. I only know of 11 APDs that were approved in that first 60 days under the Biden administration. And they're all done by Vernal for the Price Field Office. This administration didn't have APDs, but they had other projects like right-of-way projects that involved surface disturbance. And I can't remember all of them, but that was the main impact to us. So, but we're kind of past that now. There's still some stuff that requires, excuse me, a lot of coordination, but we're pretty much past all that. So just an update on workload, or some. APDs seems to be the big topic by whomever. So statewide, for federal APDs, which includes Indian Trust or federal lease APDs, there's been 307 APDs submitted to the BLM within the state of Utah. All of them but one has come to the Vernal Field Office. The one remaining one, I believe, is in Richfield. So of those 306 that's come to Vernal, 157 are tied to federal leases, 149 are tied to Indian trust leases. We've been able to approve so far this year 323 total between the two categories. And we have, the numbers are correct, around 294 pending. Currently, as some of you may know, there's been a problem getting stuff submitted, processed because of AFMAS. They ran out of storage capacity for attachments, and that affects not just operators, but BLM as well. They've been working through the process. Hopefully it'll be back up and running soon. So while I'm on workload, if you got a question from another state, I can tell you what theirs are too, if you want. But anyway, so the other thing that's changed or come about that we're still kind of muddling through is the One Big Beautiful Bill, or OMBB, or OBBB, whatever it is. So the big changes there that affects folks here, change the APT approval period from 3 years to 4 years with no extensions. So now we have 3 approval periods that you all are dealing with. One's a 2-year with the option for up to 2 additional years, but those are about done. The 3-year with no options to extend. Anything processed now will be 4 years. There was some commingling language in the bill. We did get some interim policy. We're still figuring that one out. For leasing, a lot of stuff in the bill that required quarterly lease sales for 7 states now, Utah being one. Changed the royalty rates for new leases back to 12.5%, reinstated non-competitive leasing, and it removed the fee for any expressions of interest. That was probably a lot of the big stuff tied to that bill for oil and gas stuff. NEPA. You heard some other presenters talk about NEPA. We have interior guidance that we've gone through and tried to compare the differences. That'll be a part of our presentation at the Energy Summit, but in general, you heard about the extraordinary circumstance process. For NEPA, also 106, which is cultural, or Section 107, Endangered Species Act consultations. I'm aware of 2 NEPA. Those have to be approved by Interior before you start down that process. I'm aware of 2 for NEPA within BLM. They were both in Utah. One for the Pricefield office for the Wildcat loadout, and one in Monticello for a uranium mine, I believe. And I'm aware of one done for ESA that was requested through the Army Corps of Engineers for the Kinder Morgan's Green River Pipeline project. NEPA in general, we've got the new guidance. We have a lot of new NEPA templates. Now there's 433 CEs, CXs available for use. Only 5 of those pertain to wells. You saw on other slides about should be completed with 1 year and page limits. Another big change is consideration of comment periods or scoping periods. Our appeals process language has changed. There was a brief slide on project sponsor opt for NEPA. That has to be approved by CEQ to be able to be done. And there's 125% of cost. I'm not sure we know what that means yet, but it would cut the NEPA time in half if approved by CEQ. So we'll have some more information at the Energy Summit if it's a little more complete than just my notes. We also have headquarters developed call it a strike team to look at APD processing. I don't know what their timeframes or timelines are going to be. I know who's on the team. A couple of them have reached out to me for some information. I'm just not sure what they're going to come up with, particularly when I look at who's on the team and where they're from. So we'll see what happens there as well. We've also looked at what we can do to streamline within the office, in particular with 106, since the majority of our consultations with the TIPO office, not the SHPO office. Air quality, interaction with Fish and Wildlife Service, and then NEPA is another one. So more to come. It's been a lot of changes very quick, and it just takes time to get through the process and try to figure out what's the best way to proceed. So that's all I had. Maybe get you a little closer to back on time, hopefully. Any questions by anybody that I can try to answer? If not, I'll.
Jerry, with the loss of Jerry, with the loss of personnel, what sort of percentages of your workforce was that you lost?
I don't know. So I know what our office, bureau-wide, the numbers I heard, for example, in the probationary folks, there was a process to request a waiver to exclude whoever from that, and we were successful at that with ours. Our DM was district manager. I think the initial impact within BLM total was, been so long ago, somewhere around 800 or 900 people BLM wide. And since then, there's probably been another 900 to 1,000 people impacted with the early out stuff. Like I said, it depends on the office. Like I said, our office so far has been, at least the lands and mineral staff, it's been a minor impact so far. Doesn't mean that's going to continue that way. I don't expect, to be honest, given the priorities, I don't think we're going to, at least in Vernal, be impacted greatly. Given what I've seen on some of the budget language and discussions, I think there's more to come for other offices within the state. That's my personal opinion. I don't know that that's how it's going to happen. Any other questions?
Jerry, a question for me. Top energy producing BLM offices in the nation, maybe cover that a little bit. Vernal.
Okay, so depends on how you count the numbers, but the office that receives the most permits is Carlsbad in New Mexico. So, so far this year, Carlsbad has received 2,162 APDs. Vernal is next, overall number 2. We're number 2 in the nation. Like I said, our total between both Indian and federal is 300, received is 306. Then you drop down into North Dakota and some Wyoming offices. But from an overall number, when you include them both, if it's federal, we're number 3, but overall workload, we're number 2.
Okay, thank you.
You guys are too kind. I mean, there's more to come. Don't get me wrong. Dave's sitting here, and we were chatting earlier. Forest Service is going through their own stuff. They've got a reorg plan that's out there now. We haven't heard anything on the BLM side, at least that's been passed on. There's some other efforts. I think there's some discussions Monday maybe on some stuff between DOGM and our state office. Not sure where those conversations are going to go, but there's opportunities that BLM's taking, or both internally and others, to look at streamlining things and how maybe to get stuff done quicker, easier, better, whatever the right word is. No other questions? Thank you.
Nice job, Larry. Thank you. Moves us forward to Uinta Basin Ozone Working Group. I'm excited we have with us today Dr. Seth Lyman.
Thank you for being here. It's always good to hear. Thank you. Thanks a lot. What I'll talk about today is something that we talked about in the Ozone Working Group at our last meeting in June, which is how emissions to the atmosphere are changing in the Uinta Basin, and specifically I'll focus on methane. Methane actually is not very important for making ozone. It's not chemically reactive enough, but there's two reasons that I'm focusing on methane. One is that it's easy to track with satellites, and I'll talk just a little bit about how we do that. And whereas NOx and VOC that are important for ozone production are not easy to track with satellites. And also we can use methane kind of as a tracer for those other emissions. So I'll show you methane results, which matter, I guess, in its own right, but also you can think of it kind of as a proxy for emissions in the basin. And I guess I already talked about that. So there's this slide. All the words are too small, but you can see the dots there and kind of the bars. These are estimates that have been made of total methane emissions in the Uinta Basin over time. So the x-axis on the bottom there is time, and then the higher it is, that's the higher somebody estimated the total methane emissions from the Uinta Basin to be. And you can see it almost kind of looks like a shotgun blast there. There's a lot of different ways of doing this that I won't go into here. What we wanted to do and have been working on for a few years really is try to do this in a more systematic way, and especially in a way where we use the same method over time. And we aren't quite able to do that because of new methods that have come available that are better more recently, but I'll show you what we came up with. So what we did is we've used two methods. The reason is the method we prefer is based on a satellite called Tropomi, and we've been using that to look at what's been happening in the basin since 2019. The reason we started in 2019 is that the satellite launched in fall 2018, so we don't have data from it before that. So for the time period before that, then we're using measurements from our sites in the Uinta Basin, and then you use atmospheric models to kind of simulate where the air came from and how much methane it picked up over time. That's what I'm trying to show, even though that's not the little plume thing on the side is not for the Uinta Basin. It's just to show kind of air comes from somewhere, and we kind of track that but we don't like that method as well. Okay, hopefully that makes sense, and I don't want to get bogged down too much in the details, but if you have questions, I'd be happy to bog down in the details. So what we know first is that methane emissions in the Uinta Basin have declined. And so the blue line is methane emissions from 2013 through 2024, and you can see it trends down. If you look at 2020 to 2023, 2020 was the low point, probably because oil and gas emissions were at their low point there at the height of the pandemic. We were seeing a little upward trend through 2023 as the industry kind of bounced back from that. But then you can see a big dive to our lowest numbers ever in 2024, even as we've had higher oil and gas production, and I'll show you that here. So this orange line is total energy production in the Uinta Basin, oil plus gas in units of barrels of oil equivalent, or I think it should be millions of barrels of oil equivalent. But you can see that oil and gas production declined at least from 2014 to 2020, so that at least explains some of the decline in emissions. It's been increasing pretty dramatically since then, and yet emissions have not gone back up to where they were, and especially in 2024 went back down. So we're pretty excited about that. And again, this is total methane emissions for Uinta and Duchesne counties that we're looking at here. It's hard with the satellite to get much more kind of detailed than the whole basin. So one thing I did is look at emissions as a percentage of total energy produced. And so basically, if we produced a barrel of oil or a barrel of oil equivalent of gas, how much of that energy was lost into the atmosphere as methane? And in 2013, our estimate is 5% of the energy that was pulled out of the ground as fossil fuels was lost as methane. And by 2024, we're at about 1.5% loss. So again, we're going in the right direction there. We're happy about that. I guess I will say that this kind of trend is showing that how the industry operates is becoming more efficient in terms of emissions, right? So per amount of energy produced, there's less emissions, whereas the blue line in the previous slide is showing what's the total emissions. What the atmosphere cares about, kind of, right? What ozone production cares about is total emissions, not just the efficiency of the industry. So if we have a very efficient industry, but the industry grows dramatically, we still could have high enough emissions to keep having high ozone. Hopefully that makes sense. So we need to worry about both of those things. How efficient is the industry getting, and what are the total emissions looking like? What we find is that mostly this is correlated with natural gas production. And I'm showing on the graph here a correlation of methane emissions on the vertical axis, and then the horizontal is daily production from gas wells. But if you look at number of gas wells or other numbers related to oil and gas, or related to natural gas production specifically, that correlates with methane emissions in a given year. So part of the reason we can explain getting more efficient is that the Uinta Basin is changing to predominantly a gas basin to predominantly an oil basin. We don't see good correlation with oil production, with drilling and well completions, or with low producing wells. It's more driven by newer or higher producing wells. So that maybe gives you a little bit of an idea of why we see these changes. But looking at that a little deeper, one thing we talked about as an ozone working group is what's causing this, kind of, and I'll just walk through a few regulatory changes that have happened over that period. So the first Quad O standards were phased in over the period you see in the red box there. The Quad O-A standards were in 2016. Hopefully I have these right. Somebody who's in the regulatory world might be slapping their forehead right now. In 2022, there were modified DAQ rules specifically for LDAR, VOC control, and flaring for land administered by Utah DAQ, or AIR rather. And then in 2024, the Quad O-B standards and the Uinta and ORA federal implementation plan that both reduced emissions. The FIP was for existing facilities were implemented, and that we're thinking could have something to do with why we saw that kind of marked decline in 2024, even though production came up. And then beyond regulatory changes, really I've worked here since 2011, late 2011. I see pretty dramatic differences in how the industry operates in terms of air emissions from that time until today. And a lot of those changes are voluntary. A lot of those changes are driven by regulatory action, but just how our industry operates is a lot different. And really, if there's studies being done or that have recently been done for other basins across the U.S., including the Permian, and we're seeing the same sort of changes across the country, where for a given amount of oil and gas production, there's a lot fewer emissions. Now, going to see what's possible here. Is it possible to go to the website that's linked on that slide? So we are trying to do a better job at the Bingham Research Center. So I'm here representing the Ozone Working Group, but the study, yeah, if you can click that there. The work was done by the Bingham Research Center. We created this web app that shows these data. And, oh yeah, you guys see it, that's perfect. And it takes a little bit to come up because it's free. And if nobody logs in within about 24 hours, then and it depends on how fast the internet speed is, but it'll pop up here. And all the data I showed you, plus a whole bunch more, is available on this app for you to see. So if you stop right there for a second, then the time series trends that I showed you are here, and there's about 20 different variables related to air quality and oil and gas activity that you can select, and you can change the time interval. So if you're inclined, you can go there and dig into it. And if you're not sure how to get there, just send me an email. The last slide will be my contact information, or call me. Yeah, if you don't mind going down, you can make scatter plots. And then we don't have to go further probably, but you can download the whole data set as a CSV file. You can do whatever you want with it offline, and it shows you more detailed statistical information too. So if you play around with the data and find something interesting, then I would love it if you let me know. We'd be glad to hear from you about it. And in general, then hopefully, or our goal is to come out with more ways of getting what we've done out so other people can use it, and this is maybe a first step in that direction. I just want to say that the work on this research was funded by the Utah Legislature, Uinta County Special Service District 1, and an endowment for student research from the Anadarko Petroleum Corporation. And there's my contact information. I'd be happy to take questions.
Dr. Lyman, I've got a question if nobody else does. You showed the graphic that when we look at a percentage, based on percent of its energy, our percentage is decreasing.
Yeah.
And I know a few years back there was quite a bit of conversation about various oil and gas producing basins, and the Uinta Basin was viewed as kind of one of the leakier basins. And in your presentation, you talked about we see efficiency gains in the industry across the basins. Could you help the group understand how does it compare to some of the other basins currently?
Yeah, that's a great question. I would say, to give a definitive answer, I'd have to go back and reread some papers, but it depends on how you calculate it, is one way to say that. So traditionally, this metric is done for natural gas produced versus natural gas lost, right? Because the methane is mostly what natural gas is, and so people say, well, that's more of an apples-to-apples comparison. But that doesn't really work for oil-producing basins, because most of the energy that is produced in an oil-producing basin is oil, and gas emissions are not necessarily associated in the same way. So if you look at these numbers just looking at the amount of natural gas produced, we still have declined, but it's still a little high for other basins around the country that are natural gas basins. And we've been lumped in as a natural gas basin because of our historical production, I think, by people in science and academia is what I'm talking about, because they're the ones who kind of tend to do this sort of work. If you look at it, if you calculate it the way I have, which is total energy production, oil plus gas, then we're certainly not at the cleanest one in the country, but we're probably middle of the pack or a little worse than middle of the pack. A couple of the basins in the country that are newer and maybe are controlled by one or two large companies, those tend to be the ones that are the cleanest. Does that make sense? And it's easier for states to kind of get those two companies on board, whereas we have a whole bunch of different companies and a lot of little companies that have smaller resources and things like that, right? And I think that makes a difference. Of course, if you look at it as a percentage of natural gas production, oil-producing basins tend to look worse instead of looking at it as total energy. So I would say, like myself, I don't feel a concern like, boy, why is the basin so dirty compared to other basins or something like that. But I do think there's room to improve, and other basins in the country that we can maybe look to as an example. Does that make sense? Hopefully that's a good enough answer and not too much of a hedge. Any other questions? I guess in closing, I'll just say, like, way to go us, because we're going in the right direction. So thank you.
Nice job, thank you. Moves us forward. We're going to have a legislative and policy update along with some announcement and public comments. So with that, I'm going to ask Bart Kettle if he'll come up with the division and address a little bit of the legislative and policy updates. You go in there.
Yeah, I had to face one of my three things that I was kind of concerned about coming in this. It was slipping or tripping coming up on the podium, so we survived that one okay in spite of a little bit of a traffic jam. One of my other fears was getting up and presenting before a big group, and that one's true, because here I am and you're there. So we'll see if I can slip up on the presentation. So most of what I'm going to talk about today, pollution control tax certification, that's an incentive, it's a policy item. And what I kind of want to highlight is a lot of times when government bodies come up, the system's basically the same, there's very little change. That's actually not been true for what we're doing in a policy realm in Utah the last couple of years. Just in the last year, we had significant changes in how we recycle produced water. We had the implementation of this pollution control tax certification. And of course, you heard today, Class 6 primacy application that the division's currently seeking. So there's actually quite a few things that have happened on the policy front here recently. My name is on this. I'm Bart Kettle, Regional Operations Manager for the division, but I don't deserve credit for what's been done with this pollution control tax certification. So I want to make sure right off the bat at the front, I give the credit to the people I think that deserve it. That's our permitting group. It's one Adam Miller that's really led the charge on this, so he's prepared to bail me out if I make a mistake anywhere here on the presentation today. And that group works under Orland Wallace and the permitting group. As a group, those folks have worked hard. There's been a lot of emphasis recently, like timeliness of applications, specifically in the energy sector. And so I just want to give them a shout out. They've worked pretty hard the last few years. They've got their review times for applications for permit to drill down into the 50s the last couple of years. They're currently meeting their goal of 45 days per application this year. We'll see if they can keep pace with that. They're a relatively small group, but I wanted to give them a shout out before I got started. So pollution control was initiated in the 2024 session by House Bill 373. And essentially what it said is it told the division to go complete the certification process for oil and gas properties in the state. That led to R64912. That's the rule that these certifications are done under. That rule was passed last year in August. And at a high level, the purpose of the rule is to protect the public health and environment. And it covers two types of facilities: freestanding pollution control property and pollution control facility. Both are eligible for tax incentives. The main difference between the two is, think of them as one as like permanent on the site and one as could be moved, i.e. a well versus perhaps a solar system that helps with some process at the well. So the pollution control certification process at a high level, there's 3 steps to it. The first step being, obviously, the operator prepares the application and submits that to the division. There's a review process in there, and that can all be done electronically. I'll cover that in just a moment. That initiates the application review process with the division, where we take a look at it compared to the criteria in R64912, make sure that the primary purpose is identified, make sure that we have a demonstrated reduction in pollution, that all the pollution control equipment is functional, and that the time frames and the service date are in line and the ownership is there. After that review is completed, a letter of certification is prepared. That letter of certification is then issued to the operator, who can then submit it to the State Tax Commission for the tax incentive. And if it's denied, the operator has the ability to appeal that denial before the Division of Oil, Gas, and Mining Board. And so I'd like to take just a second and kind of talk about how the incentive process works. So if we look at, Utah is generally considered a business or an industry-friendly state. And there's 3 ways that a state primarily motivates businesses to do business in their state. One would be through science. A great example of that would be what was done in the Forge project in kind of the previous decade, which has led to some geothermal development in southwestern Utah, kind of specifically Millard and Beaver counties. Another example would be kind of a sound policy that's consistent, that industry understands and can work within. We like to call ourselves a very engaged regulatory body, so we hope we fill that niche, although that's definitely up to discussion depending on where you're at in it. And then the third way that you can incentivize items is through actual tax incentives, which is what this pollution control tax incentive is for. And so as we work through it, in order for application to be eligible, there must be a pollutant contained in the stream. There must be a quantifiable demonstration of a reduction of pollution from the installation of the equipment. And there also must be a demonstration that there's a net pollution reduction. And then, so I said I would get into the online application part. This is just a snapshot of it. This went live, I believe it was late last year. I can't remember the exact time frame now. This went live. The first round of applications have gone through. The team is currently working on about 900 applications in it. One of the things that we've noticed, we encourage you to take, if you have potential pollution control applications, please take a minute and review the rule. And if you do have questions on them, I have Adam's contact up here. He is the subject matter expert on this, and he'll help you through it. So that's it for my presentation.
Follow you around. If we have any questions, please don't miss the opportunity to bring them up. Just make sure you have the microphone.
Okay, yeah, there we go.
The question is, does this apply for all lands across the state, i.e. federal or tribal lands? And the answer is yes, it's a tax incentive for operators in the state, so it's independent of land ownership. Thank you.
Okay, great job, Bart. Thanks. That's a lot to throw together at the last minute. There's a whole bunch to that. So, little side note, and we'll get to lunch. We have lunch set up in the back. It is here, of course, but I wanted to bring up Deborah Herron real quick. She had a little bit of stuff to talk about, if you don't mind, Deborah.
Thank you. So I'm Deborah Herron with Duchesne County Economic Development, and I stepped out for a minute because we're putting up a, I would say, a world-class display of honeycomb calcite that's mined here in Duchesne County. It is, the exhibit is going to be open for the month of September, starting the 8th and then ending at the end of September. It will be open to the public on Mondays and Saturdays, but by special appointment, I'd be happy to take anybody through. So just wanted you to make this group aware of that and invite everybody to stop in at the Duchesne City Welcome Center. So thank you.
Nothing else to stand between us and lunch, but I want to thank you guys as always for being here. I always say this as we wrap these up. Please share the email invite for the next one. I apologize, I don't know exactly which day it is, I should know, but when you see those in your email, you all know of people that you would like to see here or have involved in this. Please share that with them. With that, let's grab some lunch, and also please thank Melissa Hughes back here. Tell her a big thank you for everything that she does behind the scenes. Let's grab something to eat and mingle.